All rise, the Court of Appeals Division 1 is now in session.
Please be seated. Okay. All right, good morning. We are here for argument in CV24-0565, Tirado versus Tirado. Am I saying that correctly?
I think so.
Okay.
Tirado.
Just a reminder, and since it's mostly our staff, hopefully they've already done this, but please silence your phones so that we avoid any disruption or embarrassment. And as I know you both are well aware, we do record and live stream these proceedings, so we'll ask that you introduce yourself when you stand up. You each have the maximum of 20 minutes per side, although you are not obligated to use all of that time. And as for the appellant, it is your obligation to keep your time. Now, as you know, we have reviewed the briefing as well as the record. We have already conferenced the case this morning. And with that, you may proceed.
May it please the court, my name is David Abney. I'm here representing Guadalupe Tirado, also known as the husband or the former husband or the respondent. He has many aliases. As I was driving into court today, I was listening to the introduction to a new translation of the Odyssey by Daniel Mendelsohn, supposed to be absolutely superb, which is one of my favorite books. Of course, one of the themes of the Odyssey is a voyage to get home. In fact, Odysseus was twice offered immunity, once by Circe, once by Calypso, and he turned it down both times. He said, if I could just get close enough to Ithaca to see the smoke rising from the hearth of my home, I could die a happy man. And here really, what kicked this off was a fight about a home. In 2016, there was a decree of divorce and dissolution of the marriage that would have awarded the home to the wife. But Mr. Tirado was sick. He's recovering from a terrible accident, and he has been living there. He was living there continuously after she moved out in 2015. He's still living there at this little home in San Luis in Yuma County. And what kicked off this case was in 2022, the wife all of a sudden starts eviction proceedings against the husband. And he gets a lawyer and comes back, and then they file the motion to set aside the decree of dissolution. The property aspect is particularly what they were focusing on. So he wants to stay in his home. And Judge Johnson looks at this motion to set aside and goes back and reviews everything that went on with the original default. The hearing, the transcript, the papers, and everything else. She conducts 3 days of hearings, listens to all the evidence, and decides, well, yeah, we should set this aside. Well, I think there was fraud in the court. Then the other side comes forward and says, well, hold on, you've got to set that aside because that's a horizontal appeal. You can't do that. And Judge Johnson took a look at it, and she was very concerned that she had engaged in a horizontal appeal. In fact, she closes off the last part of her order saying that this was an impermissible horizontal appeal. And that perhaps that's the big issue and the one that's important not only for this case but for other cases across Arizona. Is this a horizontal appeal? I submit the answer is no, it's not. It's not a horizontal appeal, it's not a vertical appeal, it's simply a straightforward, when you have somebody comes into your courtroom and says there was a fraud on the court. This decree of dissolution, this distribution of assets was committed through a fraud on the court, which you can bring at any time. 100 years later, you could say it was a fraud on the court and come in and get things changed.
What's our standard of review, Mr. Abney?
Pardon me?
What's our standard of review?
For your standard of review.
Are we reviewing this de novo or an abuse of discretion?
I think it's a legal question, so it would be de novo.
What's the legal question?
Was this a horizontal appeal? If it's not a horizontal appeal, it should have been left alone. Or at most, what should have happened I think in an ideal world, send it back down for an evidentiary hearing.
That's how I think of it. You have it's the family law rule, so motion to vacate. Rule
Right.
60 motion, basically. And the court granted it and then reconsidered it. Right? Am I misstating anything so far?
In a sense, yes.
Okay, tell me what I'm
The sense is the judge thought she was constrained and could not do a traditional, it looked to me like she couldn't do a traditional reconsideration in her own mind because she regarded this as a horizontal appeal. And once that came into her analysis, everything screeched to a stop. Now, she did, in a sense, reconsider what had happened before by another judge, but that's really...
But then again, she granted it and then reconsidered it.
Well, yes.
Okay.
Yes and no. I hate to be prevaricating on this, but the words are a little
I
slippery.
don't know what that means, so I assume...
Oh, I hate to be beating around the bush.
Okay.
Because it's not really a reconsideration when you get right down to it. For Judge Johnson, this is a new consideration. You know, has there been a mistake that was made? And if so, I need to fix it. Mm-hmm. But I can't go back to my original just thinking on this. I can't go back because that's our impermissible horizontal appeal.
So in answer to my original question, was there standard review? You're saying that because this is all tied down to whether she considered this a horizontal appeal, we review that issue de novo.
Right.
Okay. When I read her ruling, though, that was part of her ruling, obviously, and a big part of it, but she also talked about some of the errors that she had made in her analysis of determining that the wife lacked credibility.
Well, I think the error...
Let me finish, please. She spoke and emphasized that she had maybe overly, and definitely overly, how long have those TV screens been up back there? Or is that new?
It's new.
It's new? Okay.
Fairly new.
Sorry about that.
That's okay.
She emphasized that she had maybe given undue weight to the fact that some things were hand-delivered and some things were mailed. And says, I was wrong about that. And so I no longer find her less credible than I did.
Well, to the extent that it's a
Isn't that
reconsideration...
kind of a factual determination that we should defer to as an abuse of discretion review?
Well, I don't think you can defer to a factual determination when there was no hearing. And that's really what the relief we're seeking when you get right down to it. Send it back for a hearing where...
I read it as her saying, considering the hearing that we had, I made this decision, the hearing that you're talking about. But now I realize that I was weighing things based upon this misconception of what the rules allowed and provided for, and therefore I have changed my mind.
Well, that's in the context of her understanding what she was doing was an impermissible horizontal appeal. And it's not a horizontal appeal. It's a straightforward, but it's not vertical, of course, but it's just straightforward. Somebody comes in and says, this is fraud, I need...
For what it's worth, and I'm not speaking for the panel, but motions to vacate, set aside, reconsider are not horizontal appeals.
Right. Well, and that's an important point because we have a good judge. I mean, she spent 3 days trying to figure this out with 3 days of hearings and whatnot before she reached the conclusion that there was a fraud on the court.
What if I look at this independently? And boy, my voice cracked when I said that. What if I look at the record now and say, you did not meet the fraud on the court standard? What do I do with that?
Well, I assume that you would look at the record, but you also want to hear from the parties.
Well, I would look at the record.
And have a hearing.
No, because we now have a judge who says, what I thought was dishonesty wasn't because of the, because I misconstrued the rules. You know, it was perfectly appropriate and explainable why she hand-delivered some things and mailed other things, which I read the record now as kind of saying that seemed to be the linchpin of her original analysis. So if that falls out, what is your evidence of fraud on the court?
Well, there was evidence about the original notice of the decree of dissolution proceedings was not served. The decree itself was not served. The copy of the application of default and affidavit of default were not served. And that there was a lot of hemming and hawing, if not outright lying, about what was going to happen with the home. I mean, he's been there the whole time because it's some interesting, obviously some sort of interesting dynamic there. But he's been there, he's been paying a mortgage, he's been keeping the place up, and this is his place to stay because he's still disabled. He's considered fully disabled. The timing of this is very odd because 2016 you get the degree of disillusion and the notion that the wife's going to get the home, and then he's still staying there, and it's not until 2022 when she tries to evict him that we get back into
Did
this
something
mess.
else happen around 2022?
I don't know. Trump was running for president. I don't know what happened.
It seems like Trump's been running for president for the last 12 years.
Of course.
Maybe he got married?
He got married before that, I believe.
Yeah. But,
I mean, he understood he'd been divorced. They both understood. They both remarried.
yeah. But, I mean, maybe that's why she's like, now that the new wife's going to move in, I want you out of my house.
I don't think this is a hell hath no fury kind of situation, but pardon for that expression. I'm sorry.
H-E double hockey.
Inappropriate. But yeah, no, I don't know. Maybe she decided now was the time to get the home. She wanted money. I don't know what happened. But things have still remained frozen. Just very odd. You think the eviction proceedings would be going forward, or something would be happening. But
Sorry, go ahead.
What are you asking? What are you asking us to do? Are you asking us to send this back for a hearing?
Yes, Your Honor. That seems to be the logical
A
thing.
hearing, an oral argument,
And presentation of evidence as
an
needed.
evidentiary hearing on the motion to vacate, or motion to alter or amend the judgment.
Yes. Yes. I mean, we wound up with this order saying that I'm going to set aside the original decree, especially regarding the property allocation, after a 3-day hearing with lots of testimony and a lot of due consideration. And then all of a sudden, later, when there's this motion to alter and amend comes in, the judge has this epiphany, and the epiphany seems to be, this is an impermissible horizontal appeal.
At what point did your client know he was divorced?
I think 2016, I'm pretty sure. Because he did go down before a notary to sign some of the critical papers at the beginning. And he understood, he's not a very good English reader, but he understood from his wife that, I signed this because you can get divorced. And he's, great, I'm happy to do that. But he didn't really understand what he was signing. But yeah, that was 2016, they're divorced, and he's still staying at the house. And she's visiting him regularly still, and the daughter's involved there. It's just a whole different world down in San Luis than a lot of places, apparently, at least for this family.
Could I just clarify my understanding of your position? Your position is, and correct any of this, that this was not a horizontal appeal.
Right,
The fact that the court said it was legal error.
right.
The other things the court said are just a part of that legal error in terms of what Judge Morse was getting at on the incorrect application of the family rule with regard to service of process. That's all subsumed in the legal error of horizontal appeal. So if we were to find this was not a horizontal appeal, you're saying that this other error or issue is not a separate basis on which we could affirm the court's ruling?
I don't think so. I think her analysis is lodged firmly in the notion that this is an impermissible horizontal appeal, and everything else seems to be supporting and dealing with that particular notion. If you get rid of that notion, as you should, I hope, then you get back to an equal playing field. Let's just take a fresh look at this. And the judge's notion that she's not allowed to
Why does the judge have to have a hearing?
well, the judge would have...
This judge sat through the hearing, and if she now, let's say we disabuse her of this notion that it's an impermissible horizontal appeal.
Right.
Couldn't she just go back and say, I now have rethought everything I thought before and reconsidered it, and in light of my error with respect to the service, the different errors or different ways in which service can be accomplished, I realize I've changed my mind, and the credibility determination actually favors wife.
And something that's important, I think that would be a denial of due process for
How so?
Mr. Tirado.
You had a full opportunity to be heard.
Right.
Notice on opportunity to be heard. What is the new notice on opportunity to be heard? Every time a judge reconsiders a prior decision, it has to have a new hearing?
I don't think this is here again, we're back to this word thing. I don't think this is a reconsideration. I think this is a new, fresh motion. We want you to take a look at what should be done about what was done before. It wasn't styled a motion for reconsideration. It was a motion to set aside, and for good reason. We've got this.
Your original motion was a motion to set aside.
Right.
You're right.
And what she
What
did
was their motion after the
The
court
second
originally
motion was a
granted?
motion to set
motion,
aside.
yes, that was a motion to set aside. The first one was a motion to vacate the judgment.
Okay, sorry.
And it's a motion to set, and functionally, they may be very much the same thing, but, yeah, but I mean, there was no hearing the second time around, just boom, you know, I believe, this is an impermissible horizontal appeal. I can't do that, so we're going to go back to what happened originally. And all this other stuff, well, you know, it really wasn't as important as I thought it was, but I think that's justification for what she's trying to do when she realizes in her own thinking that she has done this error of an impermissible horizontal appeal, which has never been a hard and fast doctrine in this state, although a lot of judges will, and lawyers say, oh, horizontal appeal, oh, I've got a winner, you can't do that. And, well, you can, but this isn't a horizontal appeal at all. This is simply coming into court and saying, you've got to set this aside, you've got to vacate this, set it aside for these reasons. And when you're talking about something as important as a person's home, you really ought to have the full panoply of due process. Allow the parties to present whatever evidence they believe is proper as to why it was correct in the first instance to vacate the original decree and to deal with, well, who does have right to that property after all this time? What should be done? So in vacating it, I mean, the court, Judge Johnson, seemed to look at what she had done as effectively, you're divorced, the marriage is dissolved, but we have to deal with the house. And that is really what's important here. We've got to deal with the house. Who owns the house? Who gets to stay in the house? Who has obligations to pay for mortgages and everything else? That's the crux of this whole thing, is the home, as it was for Odysseus.
But if the default decree was set aside, then they're not divorced? Is that right?
Pardon me, Your Honor?
If the default decree was not set aside, like your client had originally asked, then they're not divorced?
Oh, no, they're divorced. And nobody, I don't think imprecision of what was done here comes back to the forefront there. But I think if you look at the various things that were filed, the crux of the matter is, yeah, okay, you're divorced, but it's the home. What happens with the home is what needs to be resolved. And understandably so, for like almost every other family in Arizona, the home is your big asset. If I may reserve my time?
Yep.
Thank you.
May it please the court. Good morning, Your Honors. My name is S. Allen Cook. I practice law here in Phoenix. I represented Yolanda Nunez on this appeal, the former Mrs. Tirado. And in relation to your question, Judge Morris, I think this might be looked at as part de novo review, but also significantly discretionary based upon findings of fact. And I would ask that the court look at the crux of what the case was that the appellant brought. And the appellant brought a case alleging that the wife had committed a fraud on him and is asking the court to set aside the decree on grounds of fraud or mistake. And all the other grounds in Rule 83 for setting aside this decree didn't apply. I mean, the first 3 of the 6 reasons was restricted to 6 months, and that didn't happen. And then the void, and that didn't happen. I mean, it's just the only thing that applied is whether or not there was a fraud on the court, and I recognize, and my client obviously has been informed, that a fraud on the court can be brought at any time, set aside a decree. And the reason that the trial court, the second time around, ruled the way she did, I believe, is because she didn't give credence to what Judge Plant had done when he granted the default decree, when he made findings about all the service being proper, for example, And she decided she didn't agree with that. And she realized later that the reason she didn't agree was because she didn't understand the rule properly or applied it properly. And so, to her credit, and you don't very often see orders like this in the Court of Appeals, where a judge says, oops, let me back up and do this. And that affected how she looked at wife's credibility, because plainly, the appellant had had 6 years in which to do this, if he wanted to. And there were a couple of things that happened. Number one, wife remarried in 2017. That's in the record, and it's admitted elsewhere that the husband remarried about 45 days before he sought relief. And it's understandable that people would do different things. There are things that might be compelling if they were in the record, but they're not. But I would submit to you that if the court doesn't have sufficient evidence to find that there's been a fraud on the court, then this is a discretionary decision by the court.
The Superior Court is making a credibility determination to determine if fraud was committed on the court, correct?
That's correct.
Okay. And, well, here's how I understand Judge Johnson to look at the situation. She originally was looking at testimony from 2016 and 2023. And between the two, she said, fraud on the court. Then on the motion to alter or amend, she says, oh, I was mistaken. I can't really look at the 2016 testimony. I can only look at the 2023 testimony. And because the previous judicial officer found that service was completed, I'm going to go ahead and I have no choice, because there's conflicting testimony at the 2023 hearing, I have no choice but to go ahead and find credibility in a way that jives with 2016. Am I close to...
I don't know that that's exactly it, Your Honor. I would say this is not about whether or not she thought there was a horizontal appeal or not.
But she does say...
She mentions it. Yes, she does. But on the other hand, she also says that she was judging wife's credibility based upon the fact that she hadn't given hand-delivered notice to her husband about the hearing. And the rule only requires that you mail it. And then she didn't like it that she didn't file a notice that she'd mailed it. But the rule doesn't require that you file a notice. All it says is that you have to mail it. Maybe it should say you have to file a notice that says you mailed it.
So your position is, if we disagree with Judge Johnson that it was a horizontal appeal, if we say there was no horizontal appeal here, your position is we can still affirm?
Yes, Your Honor.
Based on the judge's misapplication of the rule when it comes to service, where the Judge Johnson had originally said you should have hand-delivered, but the rule only required her to mail.
Well, it wasn't just that she said that. It's that she held it against wife. And so she found her not to be credible. But on the other hand, if you look at the decree, it essentially conforms to the petition for dissolution of marriage. That's what Judge Plant found. He didn't find that there were things that were misrepresented. Husband could have appeared and asked questions if he had wanted to. He didn't do that. He knew what it was. I mean, he's claimed on this appeal, and he claimed in the Superior Court that he was disabled and therefore didn't have good service. But he went to a bank and had a notary public notarize the acceptance of service. So I think it's reasonable that the court wouldn't be thinking that that's a valid claim either. And whether or not he was disabled or not doesn't necessarily mean that he's lost his mind. That's not the same thing.
Mr. Cook,
Yes, Your Honor.
Do you concede? I hate to say that word because it makes...
I don't mind you asking, Your Honor.
Nervous when we say that. But what is your argument, or are you arguing, how about that this is a horizontal appeal?
Well...
Because I'll tell you, I said it to your colleague, I think Rule 60 motions or Rule... What is it in the family rule, 83?
Yes.
Those aren't horizontal appeals. I mean, we allow courts to reconsider and set aside prior rulings based upon legal standards, et cetera, so,
If there's new evidence,
yeah.
you don't get to go back or if you have a legal
Well, there
error
was
in the
evidence. I mean,
document
he came forward
itself.
and testified about things that he said had happened, so there was clearly new evidence here.
Well, except you have more than one kind of new evidence. You have new evidence that could have been given at the time, if he'd wanted to come forward, or you have new evidence that actually nobody knew about at the time. You can't come back with new evidence because you didn't bother getting it the first time. There's no law that says that. If you choose not to appear, if you choose not to cross-examine, that doesn't mean you can save it for 6 years and then
What's your
file a
authority
motion.
for that?
Pardon?
I didn't find any authority that says it has to be evidence that couldn't have been presented at the first time.
Well, it has to be new evidence, Your Honor, is what it has to be. It can't be the same evidence. And so the evidence that was presented at the hearing itself was that this was their agreement. And if you look at the decree, you can see that it's reasonable. There wasn't that much equity in the house in any event, and wife was picking up all of the family debt, not just the encumbrance on the house, but all the family debt. So,
Okay, let me be more generic then.
Yeah.
Do you agree that motions to set aside are not horizontal appeals?
well, not in and of itself,
Okay.
but it may be based on the facts that it could be.
Become
Yes.
a horizontal appeal if there's not anything other than reconsider what you did previously.
Well, if you're asking another judge to change the factual findings of the judge that made the order, then that's what a horizontal appeal is. It's when you're trying to alter the facts when you don't have something new to add to the pile. And so in this case,
Your argument really is that there was nothing new, even though his argument is there is something new because I testified now and I'm telling you that this didn't happen.
well, except that he was defaulted, and so he didn't get to testify then because he was defaulted, and he would still be
And
defaulted.
his argument was that the reason I didn't come testify is because I'd been misled about what was going on.
It may be that he would say that,
I
but
didn't read English, she didn't explain it to me, she lied to me.
he signed the acceptance of service. He could have asked for help. He got notice by mail of the proceeding, and if he chose to, I don't remember if he was actually there or not, but I thought I read somewhere that he was, but I couldn't find the citation.
What if
in the
he had
record.
come in and said, she handed me something to sign and told me it was a will, and I signed it?
Well, I think that would have been a different trial if that had happened, Your Honor, but that isn't what happened. And
But in
if somebody,
essence, it is. He said, she told me that this is what was going to happen, and I was signing documents that didn't do what they actually did.
the fact of the matter is, Your Honor, that a person who chooses to represent themselves pro
Fool
se,
for a client.
pardon?
As a fool for a client.
No, more than that, but they're assigned and understood to have all the necessary to practice law, and they're treated like a lawyer by the court, unless that law is going to change. I mean, there's hundreds of cases, Copper State English says you.
Can be
Pardon?
if you're under drugs, that's why we have to ask people are you thinking clearly?
Sure.
He alleged that he was suffering from this disability and Oxycontin and et cetera at the time.
No, 6 years ago.
Yeah.
That's what he said.
I'm not saying it's believable. I'm just saying that it crosses some threshold at some point that this is new. He's at least explaining why this evidence, why I didn't present this evidence.
I understand, Your Honor, and I would suggest that if this is going to be the standard, then you're going to have a whole lot of appeals that you don't want, because the fact of the matter is, at some point in time, people have to be responsible.
Right.
And I would tell you, my view might be different. If he had come in 35 days after, so he's 5 days late on an appeal, and he said, I didn't know this, da-da-da-da. I've had that appeal up here, and I've had the case where the court has said, okay, I can see where it didn't get notice, didn't respond, we're going to redo it. I've had that case. But not this case where they wait 6 years, and he won't leave the residence, and so she has to take steps to get him out of the residence. And they've both known that they're divorced. There's been an admission of that here, that they both knew they were divorced, and he knew that there was a decree. He knew that she'd filed for one. He signed for acceptance of service of it, and Judge Plant made the finding that the decree that was presented for signature substantially conformed to the petition for dissolution of marriage. So that's a finding of fact. Now, you would say, well, can that be reviewed de novo? Well, he also took evidence, right? So he did that, and he found her to be credible, obviously, because he did sign the decree. And now does somebody else get to come back 6 years later? I mean, I would have made a laches argument, but that didn't happen. They didn't make the laches. It's a little late in the day to bring that back. But the fact of the matter is, they haven't proved that there's been a fraud on the court. The evidence that was presented at the hearing.
Well, then the judge changed her mind.
Well, and I think that means that the proof that the judge mentioned no longer exists. She vacated that. That doesn't exist. The only findings we have now are the findings that are in the final orders.
I don't know that it matters, but does he have any claim for reimbursement for the fact he paid the mortgage for the last 6 years? Is that any litigation like that ongoing?
Well, in the motion, the Rule 83 motion, and I'm guessing at trial too, that the mortgage that he was paying is only about half what the fair rental value of the property is.
Okay.
So if he
There would
could...
be an offset for that, so he's probably not going to get anything.
Well, if he were to pay a rent, he'd get an offset for that, for what he'd pay down. On the other hand, he's the guy that was living there too, and with the children, the party's children. And so as far as I'm concerned, the findings that are cited at some length in the appellant's brief about what she found before she vacated that order are irrelevant, because she vacated those findings. And I think that the principal factor is the fact that she was misconstruing the rules, and because she thought there were specific things provable that wife did not do, like filing a notice that she had mailed the notice of default or the hearing, that things like that she wasn't required to do, that affected her decision. I think she realized that, and I think that's the key of everything that she said in her order was, I wasn't fair. She knew that.
What would be wrong if we were to say, and I don't speak for the panel, Judge, we disagree with you that this was a horizontal appeal. Go back and now tell us whether you still reached that conclusion, the same conclusion you made the second time without that overlay. I'm telling you, you don't have to hold a hearing, because I frankly disagree with Mr. Abney that you need a new hearing on this one. But we do need her at least to consider whether she would have granted your motion to set aside without this wrong notion that there was a horizontal appeal involved.
If you perceive amusement on my face, it's because, not what you're saying, but Judge Johnson has recused herself in all of Ms. Nunez's lawyer's cases. So she would not hear it. Okay. Because the only lawyer down there that would do this for her is Sonia Ramirez.
That doesn't matter to us. So assume.
I know.
But
yeah. I don't think that's necessary, Your Honor. I mean, you can tell from the record these are poor people. And to send them back to court for another proceeding when you have a judge who disowned her own prior findings, I think is not proper. Because having disowned those findings, there is no evidence of any fraud on the court. And I would submit to you that the evidence that was there wasn't particularly reliable anyway, given how stale it was in terms of when things happen. And this is one of the reasons that we have these provisions in the rules that limit when you can bring these motions. And it's because the witnesses disappear, or minds change, or things have happened, and it's not the same anymore. And it's easy to say that somebody did something 6 years ago when they can't prove it didn't happen. Back then they might have been able to prove it didn't happen, but they can't prove it today. I mean, most people don't make a list of witnesses to track around with them when they move from place to place or get remarried or whatever, people that they would call if somebody did something. And so we have rules for that. And I think this motion, even though technically you can bring a motion for fraud on the court at any time, I would submit that what we have here is enormous delay, 6 years. And that if the appellant wanted to have somebody look at this, then he should have filed something 6 years before. And my client, evidence I think was that he had a copy of the decree, and if he didn't have a copy of the decree, he certainly knew about it because he remarried himself, and he knew she'd been remarried. And so there's no excuse for him not bringing these claims at a different time. And, you know, and although he says he was disabled, he was able to go to a bank and have this thing notarized. That's in the record. And if he can get up and go to a bank and have some, notarized in the record that was written in English, I mean, I don't see why he would have a claim now saying, oh, I didn't understand that. I understood this, but not that. And there's no evidence. There's no evidence, no findings at this time, put it that way, by the court, that wife did anything to delude him about what had happened. I mean, the petition for dissolution of marriage that he had gotten is...
Is the fact that she allowed him to continue living in the house and paying the mortgage, perhaps evidence that she was misleading him about who owned the house?
Your Honor, I did not reread the transcript before I came here. But my understanding is that her evidence was, and I can't tell you that this is true, I know from talking to her lawyer and whatever, that the reason that she didn't do anything sooner was because the children would not have had a place to live when they were with him.
I'm not asking about why she did it. I'm just saying, you said there's no evidence that she was deluding him about what happened with regard to the decree.
That's correct.
I just wondered if the fact that she didn't earlier have him move out of the house and allowed him to spend 6 years in the house paying the mortgage, is that some evidence?
Well, that's what I was answering, was the fact that...
Well, you're explaining why she did it.
Yeah.
That wasn't my question.
Well, you asked why she didn't. I thought that was the reason.
No, I didn't ask why she didn't.
My apologies.
I said, the fact that she didn't itself evidence that he was perhaps misled to believe that he still had some ownership?
I think it would depend on the evidence that was given. And I don't think it's unreasonable to be concerned more about your children than your money sometimes, that's all. But could it be? I think if there was no good cause for it, I think that might be something the court could think, weighed in terms of what he thought, but not necessarily what the decree says. And I don't know that what he thought matters if the decree says something else. If there's nothing further, I have nothing further.
Nope.
Okay, thank you.
Mr. Cook.
Thank you. Mr. Abney, you have about 3 minutes 15 if you'd like them.
Well, it's time to give the Gettysburg Address.
192 words, something like that.
You weren't there when he was given, were you?
No, I wish I had been.
I will.
Apparently it was fairly quick, though. A lot of people didn't realize that the president had spoken until he sat down. And then the other orators up there for hours on end. Must have been a hell of an event, especially since the graves were still fairly fresh. It must have been an unpleasant event. But in any event, I am confused as usual, but maybe I can undo some of the confusion. If we take a look at the June 10, 2024 order, which is index of record 102, on page 2, Judge Johnson is saying, the court acknowledges error in this case in the fact that the court did reconsider petitioner's statements made to Judge Plant at the default hearing. That's IR 102, page 2. And I think what she's saying is, okay, I messed up because I considered the statements made to Judge Plant. But how could you handle the motion to vacate the default without listening to all the evidence and considering all the documents that had been filed? So she didn't commit error in this case by reconsidering the statements made to Judge Plant. And those statements would have been positive statements. They would have been the wife saying, everything's fine, we did all this properly, I get the property. And now, after 3 days of hearings, Judge Johnson has contrary evidence. Well, you know, he was sick, he was disabled, he says he didn't understand, he says he didn't get all these documents that you say were mailed. The children say that they pick up the mail for the home from a post office box. They never saw any documents like this arriving over this time frame. So if I consider all that together, she's committing a fraud on the court, and that's bad. But in order to understand the context of everything, the judge had to consider what went on the first time around. And then she compared that with what happened in the 3 days of hearings and the other evidence that was presented. And that's a proper thing to do. She thought it was wrong. She said it was error, and it wasn't error. To answer your earlier question, if you take a look at Index of Record 102, the fifth page, it's ordered granting the petition to enforce the court order about division of property in its entirety. And she says, denying any other relief and I'm affirming the default decree of dissolution. So she's affirming their divorce, right? Except as separately amended to include the legal description of the marital property. That's what they're concerned about. Who gets the marital property? The home, which is, of course, so important. Mr. Tirado is doing what he can to try to get back on square one on this. As things stand now, he's completely wiped out. Fortunately, it's not like Odysseus. When he came home, he had to fight about 150 suitors who were camped out in his home and shoot an arrow through 12 axe handles, which is just an amazing feat. But Mr. Tirado doesn't have to do that. All he wants is to have this case sent back. If hearing, no hearing. Have it sent back and things examined without the lens of the horizontal appeal. Bingo, 0. Thank you very much for your time. I appreciate it.
Thank you both, counsel, for your arguments. We'll take the matter under advisement and issue our decision in due course. Court's adjourned.